Recording. Okay. Thank you so much and welcome to the panel on the state of teaching and scientific research exceptions. It's a pleasure for me to be here today. As you know, part of Communia, we have been involved in the discussions surrounding the teaching exception for many years, even preceding the new copyright directive. I think we can claim to be one of the organizations that has instigated the Commission to try to harmonize the landscape for educational uses. We obviously didn't succeed in our intents of harmonizing the education exception that then existed just at the InfoSoc level. The Commission went into another direction and created a different parallel exception. And as we, approach the deadline for the implementation of the directive, next week is the deadline for the implementation. We know that most of the countries have not yet implemented except the Article 5 nor the Article 2 or 3 of the provisions of the DSM directive, neither the remaining parts of the directive. We at least can see some trends. So we know, for instance, in terms of Article 5, we have seen implementations in the Netherlands, Germany, and Hungary. And in terms of language, there's about 10 countries in which we have seen at least some draft proposals. And of course, we are seeing some trends already, and trends that come perhaps due to a lack of knowledge or a lack of interest in making use of the flexibilities that both directives give. So we have seen things like some countries improving their existing education exceptions that were based in the InfoSoc, but still having a new exception based on the DSM, and therefore creating these parallels and overlaps between exceptions that are quite problematic from a legal interpretation point of view. But also we have seen countries that have had very broad languages, didn't need to change anything, and still implemented new DSM education exceptions in parallel. So there's one good trend. There's only 2 countries that have made the education exception subject to license availability so far, or proposed to make the exception subject to license availability, and only for a certain few uses, which is good. But I think at this point, and without further delay, and after making this kind of overview of the situation right now, I would hand over to our first panelist, Anna Lazarova, an Internet law and doctoral researcher at the University of Sofia, to talk precisely about this relationship between the previous education exception in the InfoSoc and the new education exception on the DSM directive, and how this new exception can perhaps potentially harmonize the optional InfoSoc exception. So the floor is yours, Anna. Thank you.
Thank you, Teresa. Hello, everyone. It's really nice to be here, and thanks to the Recreating Europe team for this kind of invitation. My topic is a bit more general. I'm not going to focus on specific member states, but do a bit of an overview of the fragmented landscape of educational exceptions on EU level, and the tendency for this situation to be replicated, and even in my view, exacerbated within the ongoing copyright reform. I'd like to start with a reminder, which is of course maybe completely unnecessary for this particular audience, but it seems that national policymakers should be constantly reminded of the fact that an exception for the purposes of illustration for teaching already does exist on EU level, and it has a rather broad scope. It is embodied in the provision of Article 5.3a of the InfoSoc directive, and allows for the reproduction, communication to the public, and making available to the public by any user of works or other protected subject matter for the sole purpose of illustration for teaching, and to the extent justified by the non-commercial purpose to be achieved. As you all know, It has no restrictions in terms of beneficiaries and in terms of types of use. And most importantly, it is technology neutral. So why is the EU legislator not happy with the pre-existing provision? Because it is optional. In fact, there are no member states that don't have an exception for educational purposes in one form or another. The issue is that most limit its application in various aspects. For instance, in terms of subject matter, for example, sheet music and materials intended primarily for the educational market are excluded from the scope of the exception in France. Also, in some jurisdictions, the exception might apply to published works only, or to copyrighted works only, but not to some neighboring rights. This is, for example, the situation in Bulgaria, and I can't even tell if this was done on purpose. Also, we have restrictions to the scope per types of usage, per volume of the allowed use, of course, per beneficiaries. And of course, we have differences in terms of requirements for the payment of fair compensation. So on one hand, the exception has different scope in different member states. On the other, it may be also subject to different regimes in one member state, where certain groups of beneficiaries or types of usage entail different scope of free use. And wanting to remedy this legal uncertainty, the EU legislator attempted to adopt a mandatory minimum of user rights protection through the new Article 5 of the CDSM directive, the goal being the exception to unconditionally cover digital and cross-border uses. The new provision has a much narrower scope than the InfoSoc one, but where the InfoSoc exception is optional, the CDSM one is declared to be mandatory. It is also intended to be not overridable by contract or by TPM, so its imperative nature would be doubly protected. To what extent, however, is that conceptually reflected in the provision itself? The exception might not be optional, but almost each one of its elements may be derogated partially or fully, in some cases subject to a suitable license, in others at the member state's full discretion. So national implementation may vary in terms of scope of works covered by the exception, in terms of types of use, volume of use, as well as, of course, fair compensation. And the most radical carve-out is the option for the exception to be overridden in its entirety by the mere existence of suitable licenses. We can see that the approach of the CDSM directive does not differ significantly from the InfoSoc approach, as it is sanctioned by the CJEU case law. So member states have a considerable leeway in how they implement Article 5, as long as they do not hinder the effective application of the exception, which will be probably assessed on a case-by-case basis. And then we have yet to see how member states are going to transpose the Article 5 exception in connection with the pre-existing one. And when the directive was adopted, I believe that the worst fear of all digital rights organizations was that the educational exception was going to be narrowed down as a result of Article 5. But I'm not sure that anyone really anticipated what seems to be the most common scenario of national implementations at the moment. For member states, in different stages of introduction of the new exception, to introduce it in parallel with the existing InfoSoc one. And many of these member states already have a rather broad technology neutral pre-existing illustration for teaching exception. And I don't think that these proposals always contain collision norms concerning the applications, the application of both exceptions. And what is even worse, in my view, many countries are introducing, I don't know if there are many, in fact, but some countries are introducing derogations by license where they never had these derogations before. And the exclusion of educational materials and sheet music seems to be particularly popular, in my view, as a direct result of the fact that the French option was included not in the recitals, but in the text of Article 5 itself. So as a conclusion, it may be a bit early to tell, but it seems unlikely for the new mandatory exception under Article 5 to to be a suitable tool for the purpose of achieving harmonization. The new exception is apparently in many cases treated not as a mandatory minimum, but as something completely different from the pre-existing InfoSoc illustration for teaching exception. It is not clear how these provisions will interact when it comes to interpretation and enforcement by the judiciary, and member states are implementing restrictions to the national educational exceptions that weren't there before. So in my view, we might be soon facing a massive legal uncertainty concerning free use for educational purposes, and I don't think that was the initial goal of the intention of the EU legislator. Thank you for your attention.
Thank you, Anna. And this was a perfect timing you really kept with the 7 minutes that we had. And now I'll hand over to Justin Jütte, an assistant professor in intellectual property law at the UCD Dublin, and Justin will talk about some of the weakness of Article 5 of the new directive, and also a bit about the Irish experience with a digital teaching exception that has been implemented in 2019 in Ireland. Thank you. The floor is yours.
Thank you very much, Teresa, and also thank you, Anna, for setting the scene so expertly, because I can now save a lot of words and really focus on a number of critical points. And I'll start indeed with the Irish experience, because in Ireland, and I only came to Ireland a couple of months ago, actually, so it's also quite new to me, there was a teaching exception pre-existing since 2019, certainly drafted with the DSM directive in mind, but it also demonstrated as a first point how flexible the exception that we already had in Article 5 of the InfoSoc directive actually was, because there was clearly the possibility to have an express exception for digital users, and this is what the Irish Parliament indeed implemented already in 2019. But certainly, as we go through some elements of the exception with a look ahead in what was about to come. So in 2019, in section 57 C, the Irish CRA, the Copyright and Related Right Act, provided for the first time a digital teaching exception, and that was relatively slim in terms of its formulation, because it simply stated that certain institutions shall not be prevented from making reproductions or communicating works for the purposes of teaching. And that was it. Now, it was a very light language and gave indeed a lot of flexibility to apply this exception. However, there was already an override included, and an override that can certainly be traced back to the proposals back then on the table for the CDSM directive, which also stipulated that if there are suitable licenses available, the exception could be overwritten by a statutory license. There are two interesting things about this licensing carve-out that pre-existed the CDSM directive. Number one, it doesn't only apply to the digital teaching exception, but it was then applied to all teaching exceptions that were already present in the CRA. So it was kind of like a wide expansion of this unprecedented licensing carve-out for the teaching exception. And another important element was that these licenses that could override the general exceptions had to be confirmed, and they had to be confirmed by the responsible minister. So any license that is being offered as an override of the general teaching exception has to go through the ministry, and the minister has to sign it off. It has to sign the wording off. So we have a good element of control here, which might be considered as a role model, at least as an element of good practice here in Ireland. And I don't have any insights, to be quite honest, how the minister then considers whether this is a suitable license or not. But that also indicates that it's very important not only to stop an examination when it comes to the exception itself, as it is laid down in the law, but also to look very, very closely in how these licenses that are considered to be suitable under Article 5 of the CDSM directive will be designed. And there are certain elements, looking at the only available license in Ireland, that are worth considering. So the only license that has been certified by the ministry under what is section 173 of the CRA is one for literary text, visual or graphic representations by the Irish Licensing Association on 4th of August in 2020. This is when it was effectively signed quasi into law. And the good thing about this license is that it goes slightly beyond what is offered by the law, because the Irish copyright law provides for certain quantitative standards of what is permitted to be used and to be communicated under the educational license. And it says more or less 5% of a work or a book chapter, an article, and so on and so forth. And the license generously expands that to 10%. But of course, there is an element of remuneration included. That's the nature of a license, obviously. But there are also a number of excluded works. So right holders can opt out of this license. So not only would a teacher or a law librarian have to look into the exception itself or the license, but also in an annex document which includes all the excluded works that aren't covered by the license, but then also arguably not really by the exception. Though this is a question for a discussion. At least that's what I would argue. So the main message of my first point is we cannot only focus on the exception itself, but we really have to take care that the licenses are being drafted very carefully. Now, one other aspect of the Irish exception is there is no mentioning of a virtual learning environment as a spatial restriction of where the teaching exception for digital purposes should take place. But this is all included in the license. This is all then subject to private ordering, subject to confirmation or sanctioning by the ministry. And this is where a general oversight mechanism comes in. The CADSM directive doesn't say what is a suitable license. There are no standards included in the CADSM directive. So this is something national legislators should be very, very careful in formulating or determining in one or the other way. Is it a license that is merely available? Is it a license that has to be cheap? Or is it a license that also provides for a convenient way of interacting in a digital way with teaching materials? This is a question I think is fundamentally open and national legislators, but also then negotiations between right holders and users should have regard to this element of suitability. Yes, I see the 1 minute, I'm almost done, no worries. And the third point, which is something I stumbled upon quite recently, is how are these licenses, if they are indeed being implemented, are actually going to be enforced? Looking at my own library here at UCD, it states relatively bluntly that right holders will have access to our virtual learning environments to see whether there are works available that aren't covered by the license that is currently in place. And I, as a copyright lawyer, have fundamental problems with that, because eventually my fear is, which I had at the very beginning already, which has been watered down to a certain extent and now resurfaced, are we suddenly turning virtual learning environments in universities in online content sharing service providers? This is certainly something that I personally would heavily want to avoid. Thank you very much.
Thank you, Justin. That was really interesting to hear from the Irish experience. And as I said, so far, only 2 countries, one was Germany and the other Czechia, have adopted or proposed to implement the new education exception subject to license availability, which is good, because honestly, I do think the system as it is, it's as you mentioned, not perfect and would create several problems. So I'll now hand over to Katarzyna Klafkowska. She's a professor at the Adam Mickiewicz University of Poznań, and I'm sure I've made some mistakes here. She will talk about the experience of the implementation in Poland of the, I'm not sure if it's just of the education exception or maybe also of the text and not the mining exception, because this is the panel also about research. So let's see. The floor is yours, Katarzyna. Thank you.
Thank you, Teresa. I will cover only education, so teaching purpose rather than than research, but we can get to this in the discussion. So I am very grateful to be invited to this workshop, and also I enjoyed my expert contribution to the works of Recreating Europe, and I'm very pleased to discuss the research and education in this panel, as I think it poses a lot of interesting theoretical and practical questions, as already the previous speaker have noted. And they all come, according to me, to one central question: is how far do we want to go with the exceptions and limitations for education? In Poland, these exceptions, the exceptions, the so-called permitted use for education, is quite well established, because we've had it in all our copyright acts starting in the 20s of the 20th century. So I find it pretty firmly established in society, in the knowledge of students, in the knowledge of teachers. And I think the society in general is quite used to the flexibility. Perhaps this is a kind of a knowledge gap a bit, but the general idea is that it is a flexible use for, at least for educational institutions. And here I give a short overview of the uses linked to education, from general ones like private use or quotation to more particular ones like performing works at school or academic celebrations. But I would like to focus more on one particular provision of our Copyright Act, because it is most closely linked to the provisions of both directives that Anna Lazarova already explained and explained in details. So this provision has been introduced in the 90s and has been amended 3 times. And it was also amended to adjust it a bit more to the requirements of EU law. So this is from EU law that we get the phrase, the purpose of illustrating the content for in the process of conveying knowledge. And we also have already existing particular digital use. So what is included in our statute is the clarification that the use covers also making available on demand, but in the controlled environment. So a little bit in line with what is provided now in the directive. And coming back to the questions, how far do we want to go with the exceptions for education, both in EU law and in Poland? I find the following limitations stemming from the EU law, from both the InfoSoc directive, you can see that above, and from the CDSM directive, in case of the digital use of works. So we incorporate this in our Copyright Act, especially the sole purpose of illustration for teaching, indication of the source is the general clause and for all exceptions and limitations provided in our Copyright Act. And I think that the CDSM directive strengthens the approach that is focused on educational establishments. And we already have this in our law, but I find it now reinforced with the new CDSM directive. So coming to the conclusion, in the provisions of the directive, I find some promising and some not so promising concepts linked to the use for educational purpose. So the not so promising concept is the concept of the illustration for teaching. So in EU law, we stick to considering teaching activities as aligned with a kind of passive illustration for teaching. So this passive approach to conveying knowledge from teacher to student. So I find some hope in the preamble of the CDSM directive, because in light of the preamble, it may be not so much static as it is. So perhaps we will be able to witness a more dynamic approach to teaching activities, despite this illustration for teaching purpose that is repeated constantly in EU law, and that I personally find redundant. However, I cannot explain it in more details. That's why I refer all those who are interested to my paper, where I discuss why I find it redundant. The more promising concept is that of responsibility of an educational establishment. I like this concept better than the technical control that is also included in Article 5. However, I know we have that express condition that it needs to be a controlled environment, but perhaps in some border cases in the future, we will make use of this concept of the responsibility of educational establishment. And I like the concept. I think the EU law is the right place to address the country of origin and cross-border uses. So this is a welcome provision in EU law. And that would be it. Thank you very much.
Thank you so much. Can you stop? Okay, thank you so much, Katarzyna. That was very interesting to hear, and I know very well that Poland was already prepared, and there's a very good exception, and hopefully is one of those countries that will just refrain from doing anything else. So, well, now and over to Ivana Kunda. She's a Vice Dean for Research and Chair Professor in International and European Private Law at University of Rijeka. And she will make a brief comparison of the state of exceptions in Croatia before the implementation and now in the proposed legislation. Croatia that, as far as education was concerned, was not ready for the digital environment, and now let's see what they are doing. So the floor is yours, Ivana.
Thank you very much, Teresa, for the introduction, and thank you all speakers that preceded me, which laid a very good ground for me to just go into the very essence of the problem without the need to discuss any context thereof. So the copyright exceptions which were existing or which exist right now in Croatian copyright law have been for many decades or even longer in less elaborate way present in Croatian copyright law, but usually the way they are applied now dates back to the amendments in 2003. And at that time, we had a couple of provisions which could be related or which were directly mentioning the teaching purposes. That was Article 85 on collection intended for teaching and research, which meant that it is possible to make a selected collection for the purpose of teaching of different copyright works and to reproduce it on paper or similar medium and distribute among students. So the similar medium was something that necessitated some sort of interpretation once we faced the situation of lockdown in the recent crisis, and there was a need to make some things available to students more readily than before. And interpretation actually in practice was very narrow, which meant that it excluded the possibility to make these collections of different copyright works and distributed in electronic form. So it seemed perhaps at a certain moment a bit technically neutral, but the practical application of this provision showed it was not apt for electronic environment, digital environment. The idea was that similar medium, if we say that electronic medium is similar medium to paper, then what's left? to be dissimilar medium. That was the logic. Okay, so everybody is looking forward to the new changes. But before that, let me just briefly say that the previous act also had Article 88 about the use of works for teaching, which permitted to publicly perform a work or to present it at a stage in a form of direct teaching at school events or similar. We also had Article 90 on quotation, which relates both to teaching and research for the purpose, but the source should have been, of course, indicated. And we also had Article 84 about the limitations to the benefit of particular institutions, which could copy a last piece of work for preservation purposes, which could also be done by universities as well. So the interesting things come now that the new act is in the procedure, in the legislative procedure. The most recent text that I've seen dates back, unfortunately, to November 2020, when the government adopted the draft act, the text of the draft act, which then went to the e-counseling, and after that was heard in the parliament once, that it was a very, very difficult discussion there. So it's been, I think that was in February, and since then it's been under reconstruction before it appears again before the parliament, because there were a lot of different topics came to be controversial. As far as implementation of the new copyright directive is concerned, especially Article 5 finds its place in the draft Copyright Act in Article 194, which sticks closely to the text of the directive and includes basically transposes very directly paragraph 1, and it also does not allow any licensing. The idea is that it has to be it has to fulfill the requirements, and it is an exception, and it's not subject to any possibilities of licensing. It includes digital and internet classes, distance learning, cross-border classes, and any educational levels as there. But it also includes lifelong learning, and which is also specifically indicated in the article. It says also that transposing the directive, that any provision to be otherwise is null and void. In a contractual clause would be null and void, and it says specifically that use of this limitation cannot replace the purchase of the material primarily intended for the educational market, which is I suppose something that that could cause some sort of the need to interpret further on, but I suppose that it is still a relatively narrow exception, as was pointed out by Professor Klafkowska-Waśniowska, because it is basically intended to have the purpose of providing an example, an illustration in the course of teaching. Croatia will also retain in the new act the other provisions that were existing before. They will be supplemented by some of the elements which now we find here, okay, and some sort of clarifications, let's say. So, for example, the Article 88, previous Article 88, now Article 193, will provide that there needs to be an attribution of the source and author, and that non-commercial it means irrespective of the organizational structure and financing and so on. So we see that we are aligning our previous rules to the European level. And in the end, I have to say, to close this, that we are also retaining the numerous clauses rule on the exceptions and limitations. So the Croatian copyright law is based on these exceptions to the only if they are explicitly provided in law. So the very little flexibility, as was pointed out previously in the keyword in the keynote presentation. So we see that this inflexibility is quite retained in Croatian law. Thank you for your attention.
Thank you, Ivana. That was very interesting to hear from my experience of a country that is really trying to improve the existing system, and now, without further delay, we have been given until 10 to 12, so 3 more minutes. So I would immediately, there's one question from the audience, and I will immediately pass to that question. And this question, I understand, is for Bernd, Justin. It's from Emily Hudson, and it relates to the Irish higher education license. So the question is if the collective can or claims it can access VLES to check what has been uploaded. And I'm sorry, I don't know what VLES are.
I can quickly comment on it. So VLE is what we also find in the DSM, the virtual learning environment. And I completely raised the point, and I gave Emily already in the chat a couple of pointers there. That at least on my, and I clarified, on my university website, and it's not, and we've surveyed in another project a number of other Irish and English university websites. It states that a publisher can request access to a virtual learning environment to check whether infringing content or content that goes beyond the license is available. And the thing is, it's not stated in the act itself, it isn't stated in the license. The license merely states that the education establishment has to ensure that appropriate measures, including technological protection measures, are in place that prevents the use and dissemination of unlawful material. But it seems that there is kind of like a backroom deal with publishers, and I still haven't been able to clarify where that comes from. But it's also about messaging, and I see in 52 seconds we're dead. It seems to be a bit odd that the messaging that lecturers get from their own university that might be agreed upon with publishers is relatively strict, and I could even say almost threatening that I'm being monitored by a publisher through my VLE. That was the point I was trying to make.
Yeah, thank you. And I mean, I think that question is super important. And one of the biggest problems of licenses is this power that it can give to access information. And actually, this is just anecdotal evidence, but we have heard of platforms blocking permitted uses under educational exceptions in, Google Classrooms and platforms that serve for educational purposes. So there's a lot to discuss between the interaction of licenses and exceptions. And that's it. Thank you so much.